topic of the panel is reparations and the nation. This topic is cogent and appropriate as the U.S. begins to openly grapple with questions of national identity in the so-called post-racial era and during the administration of its first African-American president. As an educator, I have been concerned with the national issue of education and reparations as they pertain to academic achievement. And as an associate editor for the Journal of African American History, the editor, V.P. Franklin, and I have made education and reparations a central topic of discussion. In a recent issue of the Journal of African American History, V.P. Franklin called for a reparations superfund, which I think we've been talking about already today. The purpose of the superfund is to provide funding to committed professionals, African Americans, and others who have developed strategies and models of intervention and remediation, according to Franklin. And it also would expand the visual and performing arts, work-study programs, and innovative academic programming in African American and minority communities. And I'll cut some of this to make it very brief so we can get on with the presentations. Earlier today, Professor Daisy Lovelace clearly pointed out Martin Luther King's support of affirmative action and reparation-type programs. W.E.B. Du Bois also made a case for African American compensation for the legacy of slavery and Jim Crow. In a seminal article, A Development of a People, he detailed the sociological and collective psychological impact of slavery on blacks and what I believe was his case for reparations. In Black Reconstruction, he showed how elites created division between whites and blacks and paid poor whites a psychological wage of whiteness that hindered unification of the white and black working class, which I would argue helped to set the stage for a popular mindset against reparations. And in his unpublished and obscure novel, AD 2150, Du Bois warned of a multicultural society where race was an afterthought, which would make the history of slavery and racism seem unreal to future generations. So as we look at reparations and the nation this afternoon, I hope to ask a few questions. Would a national apology for slavery and Jim Crow pave the way for substantive reparations? How do we promote the idea of reparations in a so-called post-racial society? And does a call for reparations become more difficult in a society that is becoming more multicultural and disconnected from the history of slavery and Jim Crow? All right, we'll start with Professor Darity.
Well, actually, we'll start with Kirsten.
Okay.
Thank you very much. Good afternoon. I'm very grateful to Professor McDowell and to the University of Virginia for this invitation to join this august company in this conversation about the future of reparations. The majority of opponents of reparations focus their attacks almost exclusively on slavery, citing its long ago past as a primary reason to dismiss any contemporary claims to redress. Rarely do their arguments address the case for reparations based upon the history of Jim Crow and ongoing racism cum discrimination. My colleague will address the legacy of Jim Crow and its justification for reparations, and I will address some of the ways white Americans have benefited from unmerited privileges that flowed from slavery. This research is part of our book project, From Here to Equality, Black Reparations in Post-Racial America, which will be published by the University of North Carolina Press. In their exceptional publication, Complicity, How the North Promoted, Prolonged, and Profited from Slavery, Anne Farrell, Joel Lang, and Jennifer Frank trace the trade beginning in 1641, when the Massachusetts Bay Colony legally recognized the institution of slavery. Virginia was already a slave trading site at this time, but Massachusetts was the first to legally sanction servitude. Supplying provisions for these slaves and for the vast plantations in the Caribbean and in South America required the efforts of a staggering number of financiers, merchants, shippers, insurers, real estate brokers, auctioneers, and laborers. While there were some who argued against the evils of slavery, the profits the institution promised those who invested in its promulgation were often too great to ignore. From the docks of Providence, Rhode Island, and Boston and Salem, Massachusetts, a round robin of outgoing ships carrying dairy products, fish, and rum followed vessels unloading slaves, sugar, and molasses. The export of goods, especially exports to the West Indies and to plantations in the American South, made possible the dramatic expansion of commerce in New England, the purchase of luxury goods from Europe, financial security, and a lifestyle of leisure unavailable up to this time. And because all commercial roads led to the slave trade, one need not actually have owned slaves in order to profit from the slave trade. Newspapers like the Hartford, Connecticut Courant, which dates from 1764 and is still being published, profited from the sale of advertisements supporting the sale and capture of slaves, adverts for slave ship crews, the provisioning of slave ships and plantations, and the sale of slave-made goods. Aetna is one of a host of insurance companies that provided coverage for slave ships and their cargoes. At least 5,000 slaves were insured in Connecticut in 1790, and according to Lang, the majority of the state's formidable institutions enslaved at least one African. Indeed, there were plantations throughout Connecticut, and while they were generally referred to as farms, the scale of these enterprises and the number of their slave personnel would have marked them as plantations had they been located in the American South, the Caribbean, and South America. Slave-grown cotton was the national currency that seeded the growth of American cities before the Civil War. Between 1821 and 1860, New York City, a major importer of cotton, became the nation's and the world's largest commercial and financial center with the aid of this good. Failed investment bank Lehman Brothers began as a cotton brokerage in Montgomery, Alabama in 1850 and would become the state of Alabama's fiscal agent at a later point. The company's founder, Henry Lehman, immigrated from Repar, Germany to Montgomery in 1844 and set up a modest shop selling groceries, dry goods, and utensils to area cotton farmers. Buoyed by strong sales, he was joined by his brothers, Emmanuel and Mayer, in 1850, and together they went into the commodities brokerage business, constructed a cotton storage warehouse, and became the area's largest buyers and sellers of cotton, phasing out their general merchandising enterprises. Like all Southern businesses, Lehman Brothers struggled during the Civil War period, and as Reconstruction unfolded, family members focused on relocating their operations in New York City. Cotton continued to trump all domestic trades, however, and in 1870, the Lehman Brothers spearheaded the formation of the New York Cotton Exchange, the first commodities futures trading venture. Meyer Lehman was appointed to its first board of directors. Real estate and shipping tycoon John Jacob Astor made his fortune in furs, the Chinese opium trade, and transporting cotton to the world's ports. Jeweler Charles Louis Tiffany opened the iconic flagship shop Tiffany's on New York City's Broadway Street in 1837 with capital from his father, Comfort Tiffany, whose own fortune had been derived from the operation of a cotton manufacturing company in what would become Danielsonville, Connecticut. New York City was booming in the late 1830s, largely as a consequence of the cotton trade. Archibald Gracie Jr., the son of Scottish international shipper Archibald Gracie of Gracie Mansion fame, left New York City to become a cotton broker in Mobile, Alabama. The cotton-producing states were integrally connected to the fortunes of New Yorkers. Historian Bernard Balin affirms that feeding and clothing the millions of slaves working the cotton plantations throughout the Americas was big business, and the income from these enterprises enriched New England and the mid-Atlantic. Slave-grown cotton made the expansion of the area's textile mills possible, some 472 institutions in 1860. One Connecticut town, Thompson, was home to 7 mills. During the decades 1830 to 1840, New England mills processed in excess of 100 million pounds of cotton grown in the South. By 1860, 10 major cotton-producing states in the South, home to 2.3 million enslaved Africans living on 75,000 cotton plantations, produced 66% of the world's cotton, and raw cotton accounted for more than half of all U.S. exports. Great Britain, France, the Netherlands, Switzerland, Germany, Russia, Italy, Spain, and Belgium were all dependent on U.S. slave-grown cotton. At least 2 Connecticut towns were built on the global production and milling of Africa-based ivory, clearly an industry that would not have existed without the slave trade. Katrina Brown's film Traces of the Trade and her cousin Thomas Norman DeWolf's book on the DeWolf family story, Inheriting the Trade, a Northern family confronts its legacy as the largest slave trading dynasty in U.S. history, look at their ancestors' extensive role in the lucrative slave and trade market. Hiring captains and crews throughout New England, they participated in the 100-plus voyages to Africa that brought over 100,000 captives to the Americas. Throughout New England, shipyards emerged to build the vessels that would become the ocean-going prisons for African slaves equipped with iron chains and shackles and water tanks. While the slave trade was legally abolished in this country in 1808, buying and selling black people simply went underground. The privileges and pampered life participants could obtain from the centuries-old practice was too enticing and too familiar for many to resist. Indeed, the complicity authors report, a conservative estimate is that during the illegal trade's peak years, 1859 and 1860, at least 2 slave ships, each built to hold between 600 and 1,000 slaves, left lower Manhattan every month. We and others, including Lorenzo Johnston Green, who's the Negro in colonial New England, 1620 to 1776, is a vital resource, contend that slavery was not contained in the American South, and the economic effects of slavery were far from limited to the South. Historian Ronald Bailey extends Green's discussion in his article, The Slave Trade and the Development of Capitalism in the United States, the Textile Industry in New England. It is time to accept our nation's tortured past for what it was, an immoral and cruel reality. The destruction of African families and clans was a key element in the wealth equation for America. African lives are the foundation upon which this nation was built. As African families were being torn apart, fortunes derived from the slave trade facilitated the growth of white families through unprecedented rates of natural reproduction. With incomes on the rise and cash and credit readily available, Americans were finding it possible to marry at younger ages and to begin to expand their families. I would like to rebut briefly the often lodged charge that, quote, slavery was so long ago, there's no reason to even bring it up. From a generational perspective, American slavery was not that long ago. Ended in 1865, now 148 years ago. If a new generation comes into existence every 30 years, the youngest generation is the 5th generation since the end of slavery on average. But in some families, the generational distance is much narrower. In my mother's family, I, Kirsten Mullen, am a member of the 4th generation since slavery, following my mother, Avis Ann Mullen, her mother, Harriet Tolliver Mitchell, who died 3 years ago, and her father, Walker Tolliver, who was born in slavery. All of my life, I have heard stories about Walker, a minister who was born in Caroline County, Virginia, and his wife, Hattie. Portraits of the couple hang in my mother's home. On my father's side, there is my father, James Otis Mullen, his father, Otis Mullen, Otis's father, Delu Mullen, and Delu's mother, Sally, who was enslaved by her common-law husband and with whom she had 7 children. Otis Mullen said, when presented with our son Aiden, his great-grandchild, not long after Aiden's birth, that he was the 5th generation. He held him up. The 5th generation. Kenneth Lewis, candidate for U.S. Senate from North Carolina in 2008, his grandmother was born in slavery. He's younger than I am. The Black Caldwell family with connections to the University of North Carolina at Chapel Hill is another family with a grandfather who was born into slavery. My partner, Sandy Darity Jr., may have also descended from such families. There's William Darity Sr., Aiden Randall Darity, born in 1900, and I believe his father was enslaved. And on his mother's side, Evangeline Royal Darity, Ossie Mae Jenkins Royal, Tassie Body Jenkins, and her parents were born into slavery. I have not begun to speak of the effects of slavery to the present or effects of not providing the congressionally mandated 40 acres and a mule to the ex-slaves. But clearly, there were many, many long-lasting effects of the slave trade on the fortunes of white Americans.
So I would like to actually shift gears again a bit and argue that the case for reparations could be built fully on the injuries imposed upon blacks in the USA after slavery. So I'm definitely an advocate of the view that slavery is a basis for reparations, but I also am an advocate of the view that the injuries that occurred after slavery took place are a firm foundation for making a case for slavery. And I believe Boris Bitger's book, The Case for Black Reparations, which was published in 1973, was mentioned a bit earlier. In that book, Bitger sought to construct a brief for judicial reparations entirely on the basis of the wrongs of the Jim Crow era, nearly a century long in its own right, directly affecting 3 generations of black Americans. So what are the harms of the post-slavery period? The first, I would argue, is a failure to provide a wealth endowment to the ex-slaves. That is to say, a refusal to fulfill the legal commitment to 40 acres and a mule, or more precisely, a legal commitment to 40 acres. I'm not sure that any of the legislation actually mentioned the mule, but the notion of the mule is actually the materials that would be utilized for the purposes of tilling the soil. Indeed, the commitment to 40 acres and a mule is a promise that's explicitly made in the first Freedmen's Bureau Act. People pretend that this particular act was not legislated, or the articles concerning the land grant to the ex-slaves was removed. This is not the case. The legislation explicitly refers to up to 40 acres being provided to the ex-slaves with the proviso that they could purchase the land at low cost within 3 years of settlement on it. Second, the White Terror campaign functioned to disenfranchise blacks almost immediately after the onset of the Reconstruction era. There was a wave of assassinations of black elected officials. The state of South Carolina provides perhaps the most extreme example. This is also the state whose Reconstruction legislature achieved the most dramatic reforms. Mass disenfranchisement was also associated with the exercise of municipal coup d'etat. In Wilmington in 1898, we had one of the most significant coup d'etats that took place at the city level. Frequently, historians have argued that this was the first major municipal coup d'etat in the United States. They also sometimes argue that it's the only municipal coup d'etat. This is not, in fact, true. Coushatta, Louisiana, in August 1874 was the first municipal coup d'etat, and I would argue that there was a sequence of them that took place subsequently to that. In fact, some people might argue that the degree of violence in Louisiana associated with the elimination of black participation in the political process is virtually unfathomable. But there was a host of riots. The Danville Riot in 1876 was precipitated by people walking down the sidewalk and black people refusing to step off the sidewalk in Danville, Virginia. In Wilmington in 1898, we have a riot that's associated with the termination of the fusion movement in the state of North Carolina. Fusion government was a mixture of the Republican Party and the Farm Labor Party, which I guess at that point was called the Progressive Party. This government actually had control of the state for a period of about 6 years. And one could argue that it was the last remnant of the Reconstruction period in the United States. They are in the city of Wilmington. The duly elected government is overthrown. Folks are told to submit their resignations at gunpoint, and then they're driven out of the city. So Wilmington in 1898 then provides the template for the Atlanta riot of 1906. The fomenters of the Atlanta riot were in close communication with the folks who executed the Wilmington riot and actually modeled their progression of events, particularly using the newspapers as incendiary devices for the purposes of actually shaping the massacre that took place in Atlanta. In addition, of course, through the interval from 1918 up till about 1923 or 1924, there was a series of riots in the state of Florida. We also had the Tulsa Riot, which Al Brophy has written about in great detail, that took place in 1921. There was the riot in Philadelphia in 1918, Chicago in 1919, Omaha, Nebraska in 1919. In effect, there was a reign of terror that was being maintained, and one of the objectives of this reign of terror was the destruction of black property and black communities. Furthermore, throughout at least the first half of the 20th century, and I think maybe you're discovering evidence that it extends further than that, the use of lynchings was a central mechanism for maintaining the kind of terror that would would achieve control over the black population in the South. Well, not just the South, actually, because there was a wave of lynchings in a number of the northern states, particularly Ohio and Illinois. Okay, so that said, that's the second item on the list of indictments associated with the effects of the post-slavery period. Third, there is a whole process of seizure and appropriation of black property that took place throughout much of the early part of the 20th century, especially land. So we were having a conversation a little earlier with, I don't know if she's still here, Lisa Crooms-Robinson? She'll be back, okay. And she was talking about her own family's loss of land and their inability to prove ownership because of the burning of a courthouse that contained the deeds that indicated that they had possession of this piece of property. Actually, the burning of courthouses, particularly the sections of the courthouses that had deeds that were proof of ownership on the parts of blacks, took place in a number of instances throughout a number of southern communities. In addition, research that I've done with Jason Dietrich and David Gilkey indicates that we can demonstrate that the occupational status that blacks had achieved in 1980 and 1990 was heavily influenced by the discriminatory earnings and educational penalties that were faced by their ancestors in 1880, 1900, and 1910. In fact, we perform a statistical exercise to establish that these much older events and circumstances actually appear to have a systematic effect on the outcomes for folks virtually a century later. And connected to this is the fact that we have these enormous disparities in wealth in the United States that are linked to race. These are the largest disparities that exist in terms of economic status. So in 2005, the median net worth of white households in the United States was estimated at $134,992. The median net worth for Hispanic households was estimated at, and this is an order of magnitude lower, $18,359, while the black median net worth was estimated at $12,124. In 2009, all groups had experienced substantial reductions in net worth, but the reductions in net worth weighed so heavily on the black proportions of wealth that the ratio of black to white wealth by 2009 was 1 to 20. Okay? So white median net worth in 2009, and this is in the aftermath of the Great Recession, is $113,149. Hispanic net worth was $6,325, and black net worth was a mere $5,677. Now, a standard kind of narrative that we have about the sources of this disparities is an argument that, well, this must be attributable to the fact that black folks are profligate, that we don't save anything, we purchase all this bling. Okay, so. But in fact, if you control for household income, there's no disparity in savings rates between blacks and whites. Now, to be frank, nobody saves much in the United States, okay, whether they are black or white. But in some income categories, the black savings rate is actually slightly higher than the white savings rate. Moreover, if you were to examine portfolio management, you would find that if you control for, once again, household income, there is no difference in rates of return that are earned on portfolios between blacks and whites. So what accounts for this massive gap in wealth? I would argue that it's the intergenerational transfer process that takes the form of inheritances and, even more significantly perhaps, in vivo transfers. Now, what's an in vivo transfer? An in vivo transfer is a shift in resources across generations that occurs when living donors provide the resources to the younger generation. And this can take a variety of forms, some of which seem fairly innocuous to us. If a young couple is newly married and their relatives arrange to try to support them in making the down payment for a mortgage on a new home, that's an in vivo transfer. If any of us have been college or university students and our parents have helped finance our education. That's an in vivo transfer. The setting up of a trust fund for a newly born infant in a family is an in vivo transfer. The capacity to make these kinds of transfers is contingent upon the prior wealth position that's been achieved by the family. And as I've pointed out, there's a historical process of destruction of black wealth and accumulated property. With respect to education, of course, there has to be a case for compensation for the maintenance of legalized segregated schooling in the United States from the 1880s up until the 1954 Brown versus Board decision, and the maintenance of segregated schooling even beyond that up until the early 1970s as a consequence of massive resistance. Indeed, we then need to examine the question of what happened after school desegregation. And I would argue that in the post-desegregation period, what we have had is desegregated schools with segregated education via the mechanism of racialized tracking within schools, so that black kids are disproportionately concentrated in the least challenging courses that the schools may offer. But moreover, educational attainment still is not insulation from American racial penalties. In fact, there is evidence that relative discriminatory losses in earnings rise with educational attainment. And I point you to the work of Tomaskovich Devi, Melvin Thomas, and Keisha Johnson, where they show that the proportionate loss in earnings that's attributable to discrimination actually gets higher as blacks become better educated. Moreover, if we look at unemployment or the opportunities for work, we know that there's a historical stylized fact that has been maintained ever since we began to gather unemployment statistics in the United States, that the black to white ratio of unemployment stays roughly at a 2-to-1 proportion. So I would add further that this ratio, this 2-to-1 ratio, exists at all levels of educational attainment. And in 2011, the unemployment rate for blacks with some college education actually was higher than the unemployment rate for whites who had not completed high school. Okay. In addition, the persistence of discrimination is evident in Diva Pager's disturbing study, which some of you may be familiar with. Sociologist at Princeton who conducted field experiments in New York City and Milwaukee, where she demonstrated that the callback rates for job opportunities for black men with no criminal records were lower than callback rates for white men with criminal records in the same age and educational attainment categories. Indeed, the racialized interface with the criminal justice system itself represents another point of emphasis in terms of post-slavery causes for reparations. The mass incarceration process, the use of phenotype as a mechanism in the sentencing process, and these cumulative effects in turn lead to vast health disparities, because I would argue that there are racialized traumas that people are experiencing as a consequence of all of these kinds of pressures that can explain the elevated rates of hypertension in the African American population. So the last observation I want to make concerns the fact that some opponents of reparations frequently say, well, you know, since slavery was so long ago, there are no living victims. And so all of our strategies for compensation must be predicated on the existence of living victims who should be paid for the damages that they've encountered. Well, intrinsically, there are living victims of ongoing racism and discrimination. Okay. Moreover, there are still living victims of Jim Crow. In fact, I was born early enough, and Kirsten was born early enough. Deborah McDowell was born early enough, Michael Dawson, to have been born into a world where Jim Crow still existed. Okay. This may be unfathomable to some of the younger people in the audience, but we were here. And virtually all of our parents lived at least half of their lives under Jim Crow, and a few of them are still living as well. So there are some living victims of Jim Crow. Now, of course, if we wait long enough, that will not be the case. Just as the United States has waited so long to provide 40 acres and a mule, indeed, in the state of North Carolina, we have had a eugenic sterilization program. And the eugenic sterilization program only went out of operation in the early part of the 1970s. Okay? There have been claims brought forward for compensation from the state of North Carolina that have not been met. Okay? Just as the Tulsa Riot victims have never received compensation. Interestingly enough, one of the victims of eugenic sterilization, which was an involuntary sterilization program, says, you know, they're just waiting till all of us die. Well, let's not wait till all of us die. But if the nation waits beyond my lifetime, the delay is not a rationale for failing to eventually provide compensation, because we can systematically demonstrate that there have been adverse intergenerational effects of slavery, Jim Crow, and today's current acts of discrimination.
Always wonderful to be on a panel with you, Sandy. And I want to thank Deborah and Lori and Kim for getting a lot of us who've been thinking about reparations back together to really, I think, revitalize this conversation, which I think is much needed. So with my time, I want to talk about juridical groundings for reparations, and through the lens of juridical groundings, also think about then philosophical justifications and how they implicate how we understand the state's relationship to race and to slavery. And even though we didn't plan it this way, I think that my remarks follow perfectly on Kirsten's and Sandy's. So what I want to do is sort of articulate kind of a way to kind of theoretically frame the various injuries of slavery, and then consider how that framing might affect how we articulate juridical understandings of reparations and whether those can be defended or not. So I end up casting the injury of slavery as cast, and in my longer paper I give sort of a very thick description of what I mean by that. Just today, because I want to keep it brief, I use three, I think, probably unexpected social thinkers to frame how we think about the injuries of slavery. Because again, I think in these contexts where we're talking about slavery, and this came up again even at lunch today, we find that each generation this question seems to arise anew. You know, what exactly was so bad about it? Or why can't you let it go? Or how is it different from marriage? Or how is it different from, I get that one a lot. Or how is it different from from my Marxist colleagues? How is it different from class exploitation of white workers? So I use Orlando Patterson, which is not a popular framework, but I'm happy to talk about that during question and answer. Sandy's heard me talk about before. But I think, you know, whether Patterson remains, you know, an ongoing. Sandy, calm yourself. So, well, here's the piece of Patterson that I find particularly helpful in being able to articulate slavery's injury in a very succinct and compelling way. It's his notion of social death and then the accompanying notion of social rebirth or denial of social rebirth. So Patterson argues that the injury of slavery, or what demarcates slavery from other structures of social subordination, is the social death of the slave, which he articulates through a whole variety of mechanisms. And then for my purposes, in particular, that if slaves are socially dead, then the removal of enslaved status, that is manumission or emancipation, should permit social rebirth. So one of the things he's argued that I think has been somewhat underattended in his work is that a measure of slave status in any given society is not just the social negation, but what happens when you remove slave status and the person becomes free. To what extent do they shed all of the disabilities of slavery and become fully a citizen of your society? And I think that this notion of social rebirth is so important in understanding why the injuries of slavery cannot be confined to slavery, because once African Americans were emancipated, had we become fully American citizens, there would have been no issues. But part of the injury of slavery and ongoing racism in the country was that denial of social rebirth. Another social theorist that I adopt is Amartya Sen, Nobel Prize winning economist, who articulates as a measure of human well-being, as a measure of human flourishing, the notion of human well-being. He articulates the notion of capabilities. Capabilities measure how people can function, not by how much wealth you have, but your ability to put any objects or commodities that you own to good use. So then what we would see following Sen is that the biggest harm of enslavement was not the absence of black people's ability to command commodities or resources. Instead, the injury of slavery was the maldistribution, indeed the violent repression of capabilities that are crucial to human thriving in a liberal democracy and critically in a burgeoning free market economy, because I think it's important we locate slavery within the rise of industrial capitalism and the immense gains in wealth that Sandy was just discussing. And finally, Angela Davis, whose very early articulation of slavery as sexual terrorism, I think, again, is sort of under-articulated, under-theorized in contemporary understandings of slavery, and shed so much light on the institution that slavery comprised not only labor servitude, as obviously did, but also sexual servitude, and for enslaved women, reproductive servitude as well. And in fact, as we all know, enslaved black women reproduced the workforce, unlike our sister slave economies, where the slave workforce was reproduced by constant importation of new slaves. In the U.S., it was black women who did that work of actually keeping slavery going. And there's also a particularly insidious feature to the sex between black women and white men that we know that slavery structurally enabled. The vast majority of slaveholder-slave relationships that resulted in children, what I call shadow families, did not disrupt slavery's racial or sexual ordering. They reinforced it. But there's a line of cases in which a tiny minority of white men did seek to confer some sort of recognition on their shadow families, typically through freeing them and transferring very large sums of property to them, which today would be in the millions, perhaps even the small billions of dollars. Efforts that were then frustrated by laws restricting manumission, inheritance, and marriage. Now, while the number and proportion of these men who were trying to do this was very small, I argue that the threat posed by legitimized, wealthy, slaveholding shadow families living in the South was vast. Elite white men could rape, force, coerce, demand, and cajole sex from black women. They could even fall in love with them. But when these sexual outliers sought to legitimize their families through some form of property transfer or rights recognition, we apprehend the limits of white male sexual agency. One task of what I call slavery's political economy, sexual political economy, was to manage the inevitable contact between hierarchical groups. Many hierarchical societies, such as ours, conserve resources in some groups at the expense of others. Sexual and intimate relations may present particular threats to the status-based distribution of goods. Hence, one primary task of slavery's sexual regulation was to permit structural sexual access while managing the ongoing conservation of racial, sexual, and economic property among elite whites. So I think it's important that we understand that there were some private actors who may have rebelled. I call them the sexual black sheep, who may have rebelled at some of the structural subordination, and part of the task of slavery was to manage them and prevent that disruption. So what are the takeaways then from this framework of caste that I derived by putting Davis, Sen, and Patterson together? First, that slavery in the United States was state mandated. Even people who, and flowing from that the structural nature of slavery included restrictions on upper caste members who might try to disrupt the system, and restrictions on intimacy as points of potential transfer, points in which people could mobilize or change caste. The old convention of marrying up, that was not possible under slavery. In addition, slavery comprised caste in the sense that there were severe limits imposed on capabilities, the ability people, again, could have to make good use of resources. Limits on capabilities also were a way of maintaining caste. Again, very different from what we would see with working class whites at the same time, who were not structurally barred from literacy, having bank accounts, leaving money to their children, et cetera. Rebirth was denied. First, for individual slaves who managed to gain freedom in some way. We know that they were not able to gain full citizenship. And then finally, when slavery was finally abolished as a category, rebirth was violently, brutally repressed until You could maybe say that African Americans got formal equality in the late 1960s, but we know that substantive equality is still a long ways off. And finally, I'm happy to talk about this more in question and answer. I think the caste rubric really helps to distinguish what we might think of slavery exceptionalism from other forms of structural subordination. Again, marriage or class dichotomies. Now, these takeaways are crucial in trying to evaluate different juridical and philosophical groundings that are put forth and debated as a grounding for reparations. So I want to take just one. I have, in my longer paper, I have 3, but today I want to just take one, corrective justice, which a number of my legal colleagues in whom I hold them in just the greatest possible regard. These are not race scholars. These are liberal white men who had been working in the private law field and were doing really quite wonderful work in torts theory, and they said, hey, could this provide a juridical grounding for reparations? And so my heart was warmed that my colleagues who had really done no work on race were sort of caught in the reparations scholarly revolution that Al Brophy described earlier to say, hey, can't we contribute something to all of this? So I was really pleased that they did this, and yet I worried that the model that they articulated, while perhaps some might say is better than nothing, I really worry that as a juridical foundation, it really is a philosophical miscue at best in terms of what we seek by reparations, and in fact, it might be antithetical to what we seek from reparations and more broadly from reparative discourse. So let me just rehearse this a little bit more. So in law, there's 2 forms of justice, several forms of justice, but for my purposes, there's distributive justice, which emphasizes the appropriate distribution or redistribution of resources in society based on precepts of fairness or need or citizenship, etc., with tax being a classic example of distributive justice. And then in contrast, there's corrective justice, which is implemented by determining who holds an initial entitlement or right, and then determining whether another private actor has breached or violated that entitlement or right, and then assessing a remedy, which is overwhelmingly monetary relief. And here's a quote from a leading theorist of corrective justice. It does not invite judgments about the fair distribution of wealth in society, but rather about what is right between 2 particular people, considering equity and conscience, or by the ties of natural justice. So unlike distributive justice, corrective justice concerns itself with the restoration of prior positions without consideration of the justness of those prior positions. So I think some people can anticipate where I'm going with this. Okay. So let me start, though, by saying that I think there are some merits to corrective justice that I do want to outline before I take the Virginia Cavalier's sword to it. So first, as an initial matter, corrective justice, which is usually in the reparations context, is articulated as unjust enrichment, right? So corrective justice foregrounds the wrongful benefits of slavery to the nation or to individual actors who then become stand-ins for the nation. And under what they call the labor expropriation hypothesis, that the wrong of slavery is that labor was wrongly expropriated from blacks and shifted to whites, I do think that is itself useful because all too often in this country, people somehow, and it even comes from our using the term slaves, people forget that enslaved people were a captive workforce. Unlike in, say, China, where slavery was very, very ornamental, or other societies where it functions perhaps as household labor or other kinds of uses that one can have for slaves, here slaves were a captive workforce. The corrective justice model does foreground the labor piece of slavery that people are all too willing to forget, if in fact they ever knew it. Second, corrective justice also, I think, vindicates entitlements and the implications of that for what I call black economic personality. So the labor expropriation hypothesis rests on the claim that blacks, like all workers, had a right to their labor as part of their bodily integrity. Reparations styled as corrective justice for forced labor captures one significant injury to black economic personality, how slavery deprived blacks of the fundamental rights to their labor, right? And that, I think, is really important. It goes back to Sandy's point about how if the intergenerational transfer of wealth is one, and I agree with you, is one of the primary mechanisms by which we end up with these vast disparities in race today, whether it's in the economic field or in healthcare. certainly the labor expropriation hypothesis helps to make that very, very visible. Corrective justice is potentially restorative of Black economic personality in a second way as well. One of the most significant injuries of slavery, I think, is a cross-cultural, and by that I mean it's not just limited to white folks, but some Blacks embrace it as well, lingering skepticism of Blacks as economic actors. Even many who acknowledge the wrong and the harm of slavery balk at the economic thrust of reparative relief. But corrective justice discourse vindicates entitlements largely through compensatory principles. It thus legitimates and normalizes economic relief for injuries inflicted, which is the flip side of saying that it's wrong to commodify these things. Now, here's the really important piece of corrective justice. Corrective justice does not turn on the moral desert of the victim. Once wrongdoing and liability are established, corrective justice concerns itself with restoring the prior position, not affecting a moral judgment of the worthiness of the victimized individual. Now, so if I go up and I kick Deborah, right, I owe her compensation. If I've hurt her, I owe her compensation. It is no defense for me under corrective justice to say that Deborah's drunk or she's lazy or she has bad credit or she's going to squander the money on things that I don't approve of. That is not a defense under corrective justice, okay? And so corrective justice suspends judgment of Black desert, instead focusing on vindicating entitlements and righting historic wrongs. In that sense, it is very, very consonant, I think, with reparative discourse. Because so often, reparations, we talk about Black reparations, and the very next thing people say is why African Americans today are not deserving of anything, right? So we shift immediately from the injury back to Black desert. Let me see. I don't want to go talk too much here, but let me just sort of gesture though. So I do find some merits in corrective justice, right? Particularly as against distributive justice. But there's also a series of problems that I think make corrective justice as a juridical grounding irreconcilable with reparations and its goals at best, and at worst quite antithetical. So let me gesture towards just a few of these. So frequently in unjust enrichment suits, the measure of a defendant's gain is co-equal with the plaintiff's loss. And that's the underlying theory of the labor expropriation hypothesis, as though all that Blacks lost under slavery was our labor. We didn't get paid wages. But slavery in the U.S. affected Black and enslaved political, sexual, criminal, and cultural personality, and these cannot possibly be compensated under a labor expropriation model. Hanak Dagan, who posits a more radical version of the labor expropriation hypothesis, I think is quite intriguing. But I'm going to put him to the side for these purposes. Corrective justice, I think, also radically misconceives causation. Corrective justice is predicated on rectifying breaches of duty, typically by private actors, but slavery's enforced system of caste involved multiple institutions, including political and legal ones. Slavery's set of brutalizations and degradations were inflicted not just by private acts and actors, but were intimately connected to the political, economic, and sexual ordering, first of slavery and then of Jim Crow. In fact, those private actors who did attempt to defy slavery's caste regime could suffer legal or social reprobation themselves. So reparations, or corrective justice, reparations grounded in corrective justice, may not be up to the task of segregating individual wrongdoers from structurally mandated social death, repression of capabilities, and sexual servitude. Now, the other two things, I'm not going to go through them, but the other two concerns I outline are a set of legitimization concerns, that corrective justice actually legitimizes the underlying regimes in which it operates. So by restoring previous positions, it never troubles the underlying justice of the regime, which of course is one of the profound goals of reparations here. And I also have a set of anxieties that I rehearse about consumption that I'm happy to talk about. But instead, I just want to wind, during Q&A, but right now instead I just want to wind down by saying that as pleased as I am that corrective justice emerges as a model because it allows us the discursive space to really talk about juridical groundings, and in talking about juridical groundings, talk about injury and philosophical perspectives, I think in the end we need an approach that tackles the state directly and the slaveholding state directly, where we see a clear connection between the slaveholding state and the United States today versus individuals to individuals today, even if they are only mere generations apart. The nation itself is continuous. So instead, I ground that approach in Rudy and Rudy Teitel's and others' notion of transitional justice, which is obligations that states have to make good on reparations and other types of claim, other sorts of claims to groups of people who have been historically subordinated. So, thank you.
So my remarks are largely going to be a bit more comparative. I guess I'm the comparativist on the panel, and as a way of kind of, I think, discussing is a good segue from Adrienne, which is certain of the arguments pro and against reparations and apologies from other places. So, and part of it I think will show us, should be heartening, which is to say that certain of the dynamics of the debates here in the U.S. reflect what's going on in the rest of the world. So as much as we ought not despair, because these arguments have been said in other places. I'm going to begin now with candidate Obama. So on several occasions during his 2008 campaign, candidate Obama stated his opposition to race-targeted reparations, favoring instead universal policies. Quote, "I've said in the past, and I'll repeat again, that the best reparations we can provide are good schools in the inner city and jobs for people who are unemployed." Regarding an apology for slavery, Obama reportedly regarded it as, quote, "appropriate but not particularly helpful in improving the lives of black Americans," unquote. Observers widely view candidate Obama's stated position as politically prudent, strategically sound, and consistent with his seemingly race-neutral campaign. Some were disappointed, however, arguing that he had missed an opportunity to speak directly to the specific historical experiences of black Americans. But outside of the confines of U.S. electoral politics, Obama's stance and the public reactions to it reflect, in large part, bigger debates about apologies and reparations around the world and over time. So however marginal and uncommon apologies and reparations are in the U.S., on the U.S. political scene, these measures and demands for them have been deployed in a range of cases, including the resolution of World War II crimes, democratization after authoritarian rule, and most recently of colonial rule and historical injustices. While the circumstances vary, the arguments in favor and opposition are similar across cases. In general, the arguments center on three core concerns: moral propriety, cost, and efficacy. The outcomes have varied across cases, with apologies and reparations given or denied, and when given, living up to expectations to varying extents. So today I'm just going to talk about a brief discussion of the pros and cons, and then I'll return to explore what reparations might mean in the age of Obama. So John Corpy identified a field of reparation politics, which he said comprises a series of concentric circles extending from a core of transitional justice to compensation and financial compensation or some in-kind compensation, to apology and regret, and ending with the notion of communicative history. As measures extend from the core out to the outer circles, the emphasis tends to transition from punishment of perpetrators to redress for victims and their descendants. In general, reparations are widely viewed as more desirable than apologies because they involve financial and other material compensation, and therefore are judged more beneficial and meaningful to recipients. However one judges the worth of each relative to the other, they are often advocated for and against using quite similar lines of argument. So as mentioned earlier, they kind of focus on three, so I'm going to just go through the three and looking at cases outside of the U.S. So first, for propriety. For the proponents of both apologies and reparations, a central argument is that the harms justify them morally. So apologies are central to and not ancillary to reparative justice. As apologies acknowledges and does not, an apology acknowledges but does not minimize or excuse a wrong. All successful apologies and reparations contain this fundamental component. So the Canadians' 2008 apology to Aboriginal Canadians was widely judged by many as more forceful than its 1998 apology. So here you have a country that apologized twice for the same thing, under different governments, meaning different political parties. So in both, the Canadian government government acknowledged his role in the residential school system, which started at the end of the 19th century and ended in 1970, right? That is removing Aboriginal children from their parents' care forcibly. So in 2008, rather, Prime Minister Stephen Harper of the Liberal Party, so this is the Conservative Party, the Globe and Mail editorial praised him, saying that his remarks laid bare what was long denied, the ugly facts of the residential school system, and apologized sincerely and repeatedly for the federal government's role in the disgrace. The apology followed the Canadian dollars $1.9 billion settlement with residential school claimants, which was reached in April of 2006. And the settlement also included the creation of a Truth and Reconciliation Commission, which was formed in June of 2009 and has since held several meetings. And that is a topic we can discuss. Similarly, in Australia, we have the recent apology to Aboriginal Australians by Prime Minister Kevin Rudd, and this is by the Labour Prime Minister. The former Prime Minister from the Liberal Party refused to apologize. So immediately upon winning election in 2008, the Prime Minister Kevin Rudd said, quote, "We apologize for the laws and policies of successive parliaments and governments that have inflicted profound grief, suffering, and loss on our fellow citizens." Rudd also announced that he intended to assemble what he described as a bipartisan war cabinet to take seriously Aboriginal issues. Aboriginal Australians were people who were removed from their families, and they are known as collectively as the stolen generations. So far, though, Rudd's war expenditures have not included reparation payments, although Aboriginal communities continue to insist on them. Aboriginal peoples prefer legislative reparations rather than pursuing their claims in the courts because an earlier test case has failed and legal strategies are quite expensive. Even apologies that are not accompanied by reparations include clear statements of acknowledgement. The key point here is that apologies are deemed appropriate because there is general agreement about the said harms and those responsible. Opponents directly call the propriety of apologies into question. Most often, the historical facts are disputed, therefore undermining the rationale for an apology. We've talked a lot about this today. So, for example, in Australia, the former Prime Minister argued that the historical record did not clearly justify an apology. He said that there was a report that was done which established that between 3 in 10 Indigenous kids were removed from their family's care. And he rejected the report's methodology and said rather than no more than 10% of Aboriginal children were removed. So in his view, the policy, which left the majority of Aboriginal children unaffected, was lawful at the time and beneficent in its intent, not malevolent. Thus, by disqualifying the sources and rationale from which the apology and the reparations recommendations were derived, Howard deemed them both an apology and reparations inappropriate. So in a related way, detractors also question who should properly be assigned responsibility. And as we well know, that's a common argument. I didn't own slaves. I didn't take the children. Why should I be responsible? The costs. The arguments about costs are fairly straightforward, and they are made in both material and non-material terms. So referring to apologies, proponents argue that they are not material or costly, but offer great value precisely because they acknowledge wrongdoing. So the Korean World War II sex slaves, referred to euphemistically by the Japanese government as comfort women, continue to insist upon an apology and not only compensation, precisely because they desire a public statement of acknowledgement and contrition by the Japanese state and not only by the Japanese military. The government denies that it set up a military brothel system. So because Japanese courts have nearly always decided against compensation, there is no material cost to the Japanese government. However, the non-material costs are evidently quite high, given the Japanese government's ongoing and vigorous responses to World War II crimes. These non-material costs have to do with reputation, national identity, and the prevailing interpretations of Japanese history. Of course, by definition, reparations are costly, and the demands of reparations claims are rooted, as Adrienne was talking about, in claims of unjust enrichment, stolen property, and or unpaid labor. Although it is not assumed that the exact amounts can either be fully known or completely restored or returned, it is expected that reparations be more than just a token payment. According to advocates, reparations are not only just, but they are also practical. The recipients of the compensation can use the money now. So, for example, in 1998, landmark case of where over $1 billion was settled with Swiss banks over the managing of Nazi-era accounts. there was a question about who should receive these monies. So Judge Edward Corman was charged with distributing the settlement funds, and he decided that the neediest survivors would receive priority. However, American survivor groups criticized the decision, and they're arguing against him because they're saying he was going to give the money to survivors in Eastern Europe. And American survivor groups argue with that, claiming that they would not receive their fair share, and that in principle at least, whether recipients need the money is separate from whether they are owed it, right? So in practice, the question of need inevitably enters into the discussion, especially in matters of distribution. So for skeptics of apologies and reparations, the costliness, particularly of apologies, is measured not necessarily in dollars, but in wasted opportunities and energy. These views are held by people who are otherwise sympathetic to injustice claims, and this is something that Michael Dawson discussed yesterday, or for those who are implacably opposed. For the former, many feel that resources deployed to secure an apology should be directed elsewhere, and for the former, the apology is worthless and unwarranted, and really unwarranted. Moreover, opponents maintain that apologizers pay dearly in costly reputation. That is, you're kind of caving into demands and you pay in national pride. Arguably, that has been the position of the Japanese government. As importantly, they see apologies as the first step down the slippery slope to material reparations. And critics of reparations decry the enormous expenditures, whether public or private. They worry about the identification, as we know, of proper beneficiaries, and regard reparations as nothing more than undeserved handouts. And so this is something that's happened across the globe. So looking now at World War II. So many survivors view, for example, and this is a case where we would think it would be pretty clear that people would deserve reparations after World War II. But many survivors viewed reparations as blood money, the acceptance of which dishonors the victims. So shortly after World War II, Israelis passionately, this is after the establishment of the Israeli state, passionately and widely debated whether Israel should enter into negotiations with Germany over reparations. And opponents of negotiations thought it was, quote, morally absurd, in the words of Knesset Speaker Yosef Springzak. Quote, I do not want a Jewish and world history to record that we received compensation from Germany, just as I do not accept the Torah stricture that for rape one pays compensation to the father. Proponents of negotiations maintain that Germans should not be allowed to twice victimize Jews by again profiting from murder and theft. In the words of Prime Minister Ben-Gurion, quote, let not the murderers of our nation also be its heirs. At the very least, reparations recipients neither want the receipt of reparations to be conflated with reconciliation, nor do they want reparations to be viewed as just compensation. And finally, the final concern is this notion of efficacy. So here, advocates argue that apologies can generate public attention and moral reflection, hopefully fostering a degree of societal reconciliation. And I would think that certain of our conversations today would seem to support that view. A key element of apology is acknowledgement and moral judgment, which presumably no other utterance can provide. When groups insist on apologies, alone or accompanied by other actions, it is precisely because of an apology's efficacy in this regard. Armenians continue to demand an apology from the Turkish government because they believe that it will, among other things, ease Turkish and Armenian relations moving forward. I should add that every year there's usually a murder of a Turkish ambassador because they won't apologize for Armenian genocide. Similarly, recent survey research and elite interviews suggest that Israeli-Palestinian negotiations will be aided if both sides acknowledge the other's, quote, sacred values. Researchers report that when they asked a deputy chairman of Hamas about, quote, a potential Israeli apology for 1948, he brightened, saying, quote, yes, an apology is important as a beginning. It's not enough because our houses and land were taken away from us, and something has to be done about that. So this is the head of Hamas, right? So assessment of whether reparations are efficacious would seem to depend largely on the recipient's judgment. To what extent does compensation enable the recipients to achieve their desired ends? I'm going to end now with just returning, finally, I'm sure I'm coming into the end of my time, with thinking about what reparations may be in the age of Obama. So I started out saying that he started off saying I'm not interested in reparations and instead gesturing towards the notion of universal policies. And we talked, Michael Dawson talked a bit about this last night. I kind of want to return to it. So I wrote this paper right after Obama's election. I was kind of reflecting on it. And one thing I would say about it is that there was a slavery apology, as I remember, in 2006, a resolution, right? But the slavery apology didn't stimulate any kind of public discussion about slavery and Jim Crow segregation as desired. But as it turns out, some of Obama's presidential campaign did. And I don't know if you all remember, now, and I'm not being facetious here, the press reported on Michelle Obama's family's history, if you all recall, right? About how slaves helped to build the Capitol building and the White House and the lives of black butlers in the White House. And, knowledge of this history had heretofore been treated as the special possession of black historians, right? But now the country was finally seemed to be on the way of acknowledging a history long minimized and ignored. And similarly, there were journalistic investigations into the family histories of not only of Michelle Obama, but of John McCain, right? And so both CNN, NPR, and the Wall Street Journal all ran stories featuring, quote, the black McCains, right? The descendants of slaves owned by McCain's ancestors in Mississippi. But as far as I know, there has been no such sustained and wide interest in the family histories of candidates, at least as that history relates to slavery in the past 20th century presidential campaigns, right? So, I mean, one must be thankful, I suppose, for small measures, right? Before Obama's first run, political scientist Charles Henry provocatively asked whether the election of Barack Obama might be considered as a form of reparations. So he wrote that before the election, and he argued against, arguing simplistically against viewing Obama victory as either a debt paid or a form of moral rehabilitation. But the fact is, as a member of a racial minority, now that he's actually been elected into the executive, and I say this as a comparativist who studies a lot of countries around the world, it's kind of hard to say that a group is now, that a member of their group who now occupies the executive, it's hard to say that it can be easily regarded as marginal and unable to exercise state power. I mean, obviously there's something to having an African American as president. But yet, presidential powers, even if they are exercised by a minority group member, are significantly constrained by, here's my, for whom the, I put a timer to make me shut up. But anyway, I have a couple of more minutes. That presidential powers, that even if they're exercised by a minority group member, are significantly constrained by embedded institutional arrangements. And so that would certainly be true in the case of Obama. And secondly, we might wonder, and here maybe I'm trying to be a bit provocative, whether Obama's proposed policies may rightly be regarded as reparations by another name, right? So President Obama made it clear in his first and now in his second term that he sees government's role in advancing a common good through substantial public expenditures in education, urban revitalization, and healthcare. In fact, in Alfred Brophy's books, he observes that, quote, community building legislation such as that associated with the New Deal and the Great Society are, quote, probably the most popular among reparations advocates. If thought of expansively, community building encompasses these issues and others. Making a similar observation in the 2009 article, Investors Business Daily, which is a paper obviously for the business class, its editorial warned readers not to be comforted by candidate Obama's disavowal of reparations, precisely because, quote, the universal practices of health care, universal mortgage credits, and college tuition, quote, are reparations by another name. Indeed, the editorial goes further, arguing that Obama cloaks race-targeted policies in the language of universal politics, but reveals his real intentions in public statements to minority audiences and in his books. As candidate Obama said, quote, so many of the disparities that exist in the African American community today can be directly traced to inequalities passed on from early generations that suffered under the brutal legacy of slavery and Jim Crow. We still haven't fixed them. So identifying the legacy of slavery and Jim Crow segregation is certainly a core justification of reparations. So in this view, Lyndon Johnson's Great Society program might be viewed as a form of legislative reparations. It is not only then that reparations are delivered in legislative form, but that the normal legislative process, not extraordinary measures, can provide them. It would seem to be, and I'm just, this is a question, not an argument, largely a matter of terminology and framing, and we discussed this earlier. Right. William Julius Wilson, as Michael Dawson mentioned last night, similarly argued that policies designed to alleviate urban poverty must necessarily be couched in universal and not race-specific terms. In order to secure sufficient support for increased government expenditures, the policy should benefit or be seen to benefit more rather than less people. As importantly, the policy should not only be associated with a stigmatized racial minority, because such association guarantees the diminishment of wide public support and hence failure. This is the argument against it. Similarly, Daniel Sebag, who's a French political theorist, argues that affirmative action in light of enduring resistance to race-conscious policies, quote, is a policy that requires a measure of dissimulation to succeed. It's debatable whether we need these things or whether Obama's strategy may be properly described as dissimulation. But I guess I want to end here with Obama's efforts at health reform and how it was viewed and what recent scholarship shows. So Obama says at the beginning, I'm not interested in reparations. I'm going to promote these universal policies. And then Obamacare comes along. And what researchers showed is that eventually Americans, white Americans in particular, came to dislike healthcare policy once Obama said he supported it. In other words, it became racialized. It became a form of reparations. So it's not, in other words, he tried to run away from universal policies, but he cannot, because whatever he does is viewed as reparations. So it seemed to be underscoring Michael Dawson's argument last night, which is that race so deeply informs and provides the lens through which we see every policy that our attempts to run away from debates about reparations are impossible to run away from it, because once black Americans begin to assert something, it's called reparations. So we might as well fight for what we want, right? Since people are calling it reparations anyway.
One more round of applause.
Yeah, thank you for a great panel. Adrienne, I appreciated your defense of corrective justice. I think it's actually more adaptable to our goals than I think you may make it out to be. I mean, I agree that the very juridical, like within a court system, might emphasize, by some theories, the benefit to the perpetrator, et cetera. But I think of corrective justice, that is, as, in its most simplest terms, that one who causes harm from morally wrong conduct has a duty to correct the harm. And it is distinguished from distributive justice, and it's indifferent to some pre-existing or distribution. But it does imply a duty to correct an unequal distribution if that distribution was caused by wrongful conduct. And I believe the one who causes the harm can include an entity like a corporation or a nation. And I think the reparations to Japanese Americans, while inadequate, fits a corrective justice model, and that was Congress on behalf of the United States. I also think the harm can often be measured by the harm to the victim rather than the benefit to the perpetrator, including the tort example you gave of harming Deborah. We would measure it by the damage to her, whether or not you were benefited by it. And I believe that while, again, typically in specific court cases you might focus on sort of lost wages, I think corrective justice can allow for harm conceived broadly, so including lost wages and the lack of wealth accumulation that Darity talked about, and Mullen, and also the social death that you talked about. So, maybe I'm just defending something I've written about, but I think corrective justice can include that the unequal distribution included the wrongfulness of slavery and its institutions and the post-slavery Jim Crow era. And, the one final point is, I don't think it necessarily means returning to a prior position, but rather the position that would have occurred had the wrongful conduct not occurred. I realize at some point that's impossible to achieve, but the idea would be, what would the distribution of wealth and social capital be across racial lines had slavery and segregation not occurred?
So I'm afraid that you guys are going to forgive me and Kim as we become total legal geeks for a minute. So thank you for that, because my law colleagues never want to kind of parse this out with me, so I appreciate it. So just starting with your first point, corrective justice is typically litigated through the courts, right? Contracts, property, inheritance, mortgages, credit disputes, mergers between corporations. But remember, as you just said, Japanese-American internment was a legislative model, right? So, and I didn't kind of flesh out my alternative, but my alternative is to say that I think it is extremely important that the state take responsibility for this, because all of these people were acting under state authority and the legitimacy of the state, right? So to me, it seems somewhat odd to say, we want to go after only Lehman Brothers or only Lloyds of London or only X, rather than really going after the state, because the wrong wasn't from any of these individuals. The wrong was in the entire political economy. And that's why I embrace this alternative model. But that's why, to me, the Japanese-American is an excellent example of why state-based reparations claims, to me, are preferable than going out. I mean, you could also, in that instance, you could also go after each individual who arguably did a wrong there. But I think it's powerful that it came from the state, and that's, as I understand it, what the Japanese-American movement wanted was from the state. Now, to your point, though, about the measuring it by the defendant's loss, this is where it gets really, really geeky. So first, it has to be quantifiable, right? And if you're sort of thinking about the expectations model, right, of it's not restoring you to your prior position, but it's putting you where you should have been, we know that that's limited by that requirement that you demonstrate that position was certain, right? That it's predictable, it's certain, all those other kinds of little micro doctrines in there. And I think on the one hand, it's unquantifiable to try to figure out what the sexual injury was to African American people as a whole, to try to figure out what the loss of literacy means to people. I don't know if you can, you can certainly compensate for it, because that's what we're looking for with reparations, but I don't know if you can sort of actually measure it in the way that we would under conventional corrective justice models. So that's my concern with it. I understand that there are some contexts in which you really could bring, I think, private justice cases. But I think that in terms of the main area where we want to put the analytic and the strategic energy, to me, it would be in the state, that the state takes responsibility for all the things that Sandy and Kirsten were outlining, which is, we at the moment that we were becoming this massive industrial world power, it was because of slavery. And so it's the state itself that is implicated and imbricated in all of this. And it's really, in some ways, I think, the state that has the capacity to remake and transform institutions around what I think should be the goal of reparations, which is a full citizenship model, some of which would be monetary, but not all. But I think if my only enemies were the people who think corrective justice were the better grounding for reparations, I'd be very happy. So I think Kim and I are more like this compared to everyone else's way over here. So thank you for the question.
Hi, thank you so much for such great talks. I had a question for Professor Darity, actually, about something you mentioned in an earlier panel about this reparations portfolio. I was wondering if you would be willing to sort of expand on what you include in that portfolio and what form reparations takes in that model.
Yeah, I'll try. So one component is actually direct cash payment to each eligible recipient of reparations. And Kirsten and I have developed an eligibility criteria. And those criteria are the following. First, an individual would have to have had an enslaved ancestor in the United States. And second, for at least 10 years prior to the onset of the reparations program, they would have to document that they self-identified as black, colored, Negro, or African American. Okay. So the second condition is to bypass the moral hazard problem of people deciding that they're black when it's time to get reparations.
Everybody's black all of a sudden.
Yeah, okay. So that said, there would be some payment that would be made to each individual. But in addition, there could be a series of trust funds that could be established. One trust fund could be designed for the purposes of meeting the higher education expenses of some segment of of younger people in the black community. And you know, it's interesting. Education seems to be the most acceptable thing to say that you'll give black people, because you know this resonates well with the defectiveness or deficiency model. But anyway, we'll take it. Okay. A second kind of trust fund could be established. There's a tricky issue here about who would be administering it and making judgments. But people might be able to apply if they wanted to set up their own businesses to get some initial seed money to get those businesses off the ground. And so there would have to be some judgment about the viability and the credibility of the proposals. But yeah, that's another possibility. And then a third could be some kind of mechanism for asset building purposes. Apart from the actual cash payment, there might be some mechanism similar to what's been attempted in Malaysia, although, you know, with the proviso that we should be careful about what's gone wrong with how it's been done in Malaysia. But, you know, perhaps a trust fund could be established that purchases shares of stock and then reallocates them to African Americans, maybe on a needs basis. So you could have some component of the reparations portfolio that is a fixed sum that's given to every African American, and other components that might be triggered by some sort of means test that could be the basis for varying the amounts that people might be receiving.
My question is for the panel as a whole, although it takes off on the comment Professor Darity made about 40 acres and a mule. I have trouble believing that if it was a reparations scheme of the first Freedmen's Bureau's Act, would really have made any difference. In Virginia, at least, between 1870 and 1900, African Americans were remarkably successful in acquiring ownership to land. And there were black leaders like Thomas Calhoun Walker who kind of organized African Americans around these campaigns. Yeah. And yet when disfranchisement came in 1902, when streetcar and common carrier segregation by law came in the 1900s, the fact that all these black people owned small parcels of land didn't seem to really make any difference. And in fact, they just ended up losing the land eventually. Or at least many of them did. So I'm just curious, just as there's more of a kind of philosophical or jurisprudential question, what happens when there are reparations and they don't work? What happens next?
I haven't a clue. I mean, I don't know. I mean, you know, we're both dealing in the realm of speculative fiction about worlds that didn't actually take place. But let me make this comment. So there were approximately 4 million ex-slaves at the end of the Civil War. The 40 acres and a mule was predicated on the view that this would be allocated to households or families of approximately 4 people, which means that the idea was then, in principle, 10 acres per person. So if the commitment had been fulfilled, it would have been 40 million acres of land. Now, we may have a companion issue about how much of that land would have been land that the Native Americans were living on. But, you know, okay, set that aside. The premise was that the commitment was really to 40 million acres of land. Now, when you talk about black folks independently accumulating land, I think the best estimates come up to a figure of approximately 15 million acres was the total. So there's a shortfall of 25 million acres relative to the commitment that was supposed to have been made at the Reconstruction period. So I mean, it is remarkable how much black folks accumulated. But by approximately 1990 or so, we're down to an estimate of 1 million acres of land. So there's a tremendous decumulation that took place. But I would argue that that decumulation took place in the context of the Jim Crow arrangements that existed in the South, which made it possible to appropriate the land. So my response to you really is the central problem was the failure to exercise Reconstruction to its fullest. So it was the discontinuation of Reconstruction that is something that has to be central to thinking about what the case is for reparations. If Reconstruction had been fulfilled, then I don't think you would have had a situation where subsequently it would have been a ready-made climate for black land decumulation to occur in the way in which it did.
Now, I'll just say really quickly, I think it's a really fascinating question, and it almost makes me want to parse reparations as land into different pieces. So on the one hand, I feel like there is a study out there somewhere that that tracked African American material wealth or success in the 60s and 70s back to whether their family had owned land at emancipation, right? Yeah. So I don't think that we should focus on just whether the land was kept or not, but it could be the case. For instance, my own family, my mother's family, I can't remember how, but they did have land at emancipation, and that land ended up becoming a form of immense economic, social, and cultural capital for them that allowed them to send their children to college in the early part of the 20th century. Even after the land itself no longer became valuable, it served a whole variety of symbolic functions. And the other piece I think is really fascinating, at what you're getting at, is that land was valuable then because we were an agricultural economy, right? And I think part of your point, Sandy, about why this is so speculative, if we were still an agricultural economy, I think that holding on to land would very much be a key to African American success. Instead of what we've seen, which is the transformation to the manufacturing economy and now into a service economy, and the constancy is African Americans not having this, really being prevented from gaining the skills to compete in whatever the current economy is. So I think you're really onto a whole series of points that are kind of making me think through even more and more and more different forms that reparations take. But I do feel like the land itself makes me want to sort of go and read more autobiographies and narratives from the first half of the 20th century about the various uses that land meant beyond the purely economic. Or even in Harriet Jacobs' Incidents of a Slave Girl, which talks about how important it was that her grandmother owned this. She owned the store, or that she was a baker. Yep. She was a baker, but she had this small economic capital that translated into immense cultural capital that allowed her to intervene on behalf of her daughter. So I think it's a really interesting question that you posed.
I'd like to add something. The initial allocation of the 40 acres was conducted under Sherman's General Order Number 15.
Right.
Right. And it was along the border. It was along the waterfront of Georgia and South Carolina, and it included the offshore islands. Those offshore islands are no longer used for agricultural purposes. They are the richest resort areas in the United States. So even if we were no longer an agricultural society, if people had maintained possession of that land, there's no telling what functions it would be serving now.
Yeah. That's true.
Panelists for really rich and provocative and thoughtful papers, so thank you very much. And this question could be for whoever would like to answer it, but it's inspired, I guess, by Professor Mullen's comment, which I found very powerful and compelling about, during slavery and slave trading, like you're linking the destruction of African families and destruction of African American families to white wealth building. And and I think this is a continuing aspect of racism today and a continuing injury, right, is the destruction of African American families. But I guess this is sort of my question, is that I feel like among a lot of progressive theorists, there's an inability to talk about this for a lot of reasons, mostly because, conservatives, people don't want to sound like they're talking about the failure of personal responsibility, or from a feminist perspective, don't want to reinforce a kind of heteronormative family or patriarchal discourses. So, the right frames this as the breakdown of the family or the rise of single-headed households. And so progressives are wary of this, very understandably. But I do feel like, we know because of mass incarceration and unemployment and a whole host of reasons that the destruction of black families is a continuing aspect of contemporary racism. And so, but it's often absent. And, it's been absent from reparations, a lot of reparations advocacy. So my question is if you have any advice or strategies for putting this back into contemporary political advocacy and how we might begin to frame it.
Yeah. Well, thank you for that question, Martha. I'll just say really briefly that when I was on the litigation board for INCOBRA, Black family was one of the core pieces for precisely the reasons that you indicate. And I think for people like myself and probably for Lori who are trying to think about sexual reparations, it's not just through the lens of sexual autonomy, but it's also through the concomitant lens of what it means to have genealogical instability and fragility sort of built into your life. So I think you're absolutely right, and I do think you're right to sort of cue that. I think it's tricky because if you think about sort of the radical reparations advocates, I don't feel like they shy away from this. I think the more, quote, liberal reparations advocates might for a variety of reasons. So maybe it's an area where the more progressive reparations rhetoric really should be the rhetoric that's defining the discourse.
My view is, just bringing in from a comparative perspective, is that taking the Australian case and the Canadian case where you don't, my reading of it, you don't really see that disjunction part because many of the discussions are about the destruction of indigenous families, right? So a big part of it, explicitly, right, they're taking away of children and disruption of whole communities, and it's seeing as kind of destroying a nation in effect, right? So in a way, the initial framing and the initial discussion of the harm can create or not create a space for focusing on the family. And in those two cases, the nature of the harm creates quite a bit of space, arguably crowding out some other parts of dispossession.
Okay, thank you.
Thanks with you.